My name is Ron Graber, and I teach business law and principles of business law. I've been doing that since 1981, and I enjoy doing it more than I did practicing law, which I did before that. And so, yes, I am a lawyer, and so don't throw stones at me. I'm a good lawyer. I haven't sued anybody, actually. I defended people, but never actually sued anybody. Did I sue anybody? Maybe one person, but they deserved it. Anyway, yeah, I threatened to sue somebody, yeah, but no, I didn't sue him. We worked it out, we negotiated. Anyway, that's what I prefer to do. This is a welcome video, an introductory video, and I've been told that it's a good idea to start with an elephant story. Oh no, Dumbo, get out of here. I don't need an elephant, I'm sorry. It's supposed to be a relevant story, okay? And so I've thought of something I think is very relevant for today, very relevant for the subject matter, and maybe of interest to you. There's been a lot in the news lately about racism. It's been a long-term problem in America, that and equality. And so I thought it might be a good project to submit to groups of students, so dividing you up into groups, small groups, maybe no more than 5 to a group. Maybe less than that, and have you talk about, and I'm going to show you a sharecropping contract. So it's in this book by Eric Foner. It's an original document. It's historical document, actual sharecropping contract. And I'm going to actually then also give you other articles to read, also by Eric Foner, in this case, which is from his book here, in which he talks about what was wrong with the South. And one of the things that was wrong about the South were the Jim Crow laws. And so if you look at the contract, it seems to be perfectly neutral. A group of people signing with another person to do work, and they would get and they would share the benefits of that work. It seems like maybe an arrangement that many people would think would be fair, but it turns out that, and you understand the legal system in the House, how it was implemented. Those contracts were not voluntary. If you were black and you were unemployed, you could be arrested for vagrancy, and so you'd have to stay home. You wouldn't be going into town. If you went into town, they might arrest you for vagrancy, and then you'd be tried, and if you couldn't pay the fine, you would then have to, and the fines were more than you could probably pay if you were black, you would be sent to a prison farm. That is, your labor would be farmed out. It might not be a farm, it may actually be even a mine. In Alabama, they had mines where black prisoners being held for minor offenses such as vagrancy were kept in prison for a lifetime because they could never pay the fines that they were having to pay. And if you paid the fine, you would then have to go work. It frequently would be because somebody who knew you, usually a plantation owner or somebody who had a farm, came in and paid your fine, and then you would have to work for him. So some people said this was slavery by another name. And so you either signed these sharecropping contracts, and pretty much the price of cotton had been plummeting for years anyway. Pretty much you could not actually make enough picking that cotton under those contracts to actually escape and to make enough to pay your fines. And basically, oftentimes you would maybe be found to have violated your contract because you didn't show up to work every morning at 6 o'clock and stayed till midnight, 7 days a week. So the contracts were very oppressive, and very oppressively. Do we have contracts like that today? Well, we don't have sharecropping contracts, I don't think. Not like that anyway. And the system is hopefully better, but maybe there are other things. There certainly are work gangs, and part of the work that were done by the parties who were vagrant was to go to work for the state building roads. So you see in the movies maybe a group of black people pounding on rocks to make gravel. They were doing that to make roads for the county. and so the county was employing them, not paying them, but employing them, because they had been black. And when the county lent them out to other parties to work farms and mines, that money went to the county. So it was a way of making a rural economy prosperous by the work of these people who were, in a sense, virtually slaves, despite the fact that slavery had been outlawed. And so that'll be something you can see, and you can read it. It's not, you don't have to take my word for it. You'll read the articles, and you could even look at the historic documents if you want to get into it deep enough. Anyway, so we'll talk about that. And we'll talk about the 14th Amendment. We'll talk about the Constitution. And the Constitution, right now, a lot of the decisions that had arose during the first New Deal, during the first Great Depression that we had. Maybe it's not the first Great Depression, we had other depressions before it, but certainly it's one that we know about. The 20th century depression, the decisions that were made that largely were meant to bring us out of the depression. There was a concern that the Supreme Court would throw out the legislation passed, and that we'll be talking about. So we'll talk about the Constitution as part of our coverage of regulatory law. So we're going to talk about contract law, we're going to be talking about regulatory law. In that regard, we'll probably talk also about employment law and constitutional law and environmental law, all of those things. We'll be talking about equality. So not only from the point of view of racism, but we'll also be talking about it in terms of sexism. And this is a book written by Linda A.R. Monk, and she has a foreword by Ruth Bader Ginsburg. And we may look at some of the 20th century and 21st century decisions of Ginsburg, who was very much an authority and very much a person who argued very well for the increase in rights of women, which were, unfortunately, women were not given the protection of the 14th Amendment. They were not given the right to vote until we passed the 19th Amendment. I think the 14th Amendment and the 13th Amendment and the 15th Amendment, which gave the right to vote to blacks, the people who sponsored it were afraid to include women because they thought it would not pass, and probably they were right in that regard. There was a lot of sexism and a lot of thinking that, oh, women don't need this. And even amongst people who were otherwise very, very liberal on the racism issue, a lot of them were probably very sexist at the time, and so they didn't want to include it in there. And some of them didn't want to include it in there because of tactical reasons, and that's kind of interesting. So tactics is very important in the law, and so how do you interpret these things? I think you have to understand the social circumstances that surround it. That's why I'm going to give you articles that talk about the Jim Crow law. And I have a book that actually talks not about the old Jim Crow law, but about the new Jim Crow. Again, it's written by a woman, Michelle Alexander, who's a black woman, and so we'll maybe try to put some of those things in and let you look at that to see, in fact, are we in fact as good as we think we are? A lot of people think, oh, we've solved the race problem. We solved the sex problem. I think women and blacks sometimes don't agree that sexism and racism has disappeared. And I think what the problem is that a lot of people don't know their history and don't even know what the laws are now. So recent decisions of the Supreme Court have largely suppressed certain black voters. And we'll talk about that decision. We also, one of the other things I was talking about was to give people characters. So one of the characters I might talk about would be Jack Sparrow. And I think it's very interesting when we look at the Constitution. You can think of some of the statements by certain liberal judges as viewing the constitutional provisions from the Constitutional, which after all was simply a compromise. It was not meant to be a document of great wisdom for the ages. It was a compromise so that they could get together as a united country, because they were threatened by they were still worried that Britain might come back and try to take over, so they entered into this compact. And it wasn't perfect, which meant that originally they had the Articles of Confederation, and then they had the Constitution, which established a more centralized government. That was due largely to Washington and Adams, the first two presidents. After that, you had a series of presidents, largely elected by the slave power, and these presidents basically promoted the slave interests. So the 13 presidents after Adams, including Jefferson, were different. Although Jefferson is a kind of a mixed bag in some terms. He wrote the Declaration of Independence. He wrote into the Northwest Territories laws that there would be no racism ever in these territories. And so he's kind of a mixed bag. But you find that certainly Adams and Washington wanted a more centralized government, which is completely contrary to what slave owners wanted, because they wanted the states to have power because they could control the states. On the other hand, they knew that in the North, and they knew that in the world and in the North, their system, the plantation system, was not popular, so they attracted that. So we'll talk about that as a project. And I think it's very much related to contract laws, because today we have contracts that are maybe unfair. And look at some of the financial contracts. We saw that during the build-up to the crash in the 80s was largely caused by contracts that basically put a whole group of homeowners into deep debt, contracts they didn't understand, which had provisions in them that we would not, I think, no longer allow to have happen. And yet we didn't do anything for these people who were there. You might have thought that we would have gone in and maybe interpreted those contracts as not being valid, but we didn't do that. So, three areas that we're going to be talking about largely is contract, regulatory law, and also the court system, torts, and the Constitution, which are all lumped together in my presentations. And the law is kind of lumped together anyway. I mean, one part relates to the other, and so you need to understand them in relation to one another, and you need to understand them in relation to the time, place, and circumstances and the society in which these laws are passed is important. Certainly after the Civil War, one of the reasons that we didn't actually get a very effective reconstruction of the South remained a backward rural place which was dominated by a slaveocracy, even at that point you could say. And the reason we didn't have a good reconstruction was largely because there was a lot of racism north and south. And this was exploited by propagandists who persuaded Northerners that the blacks were not fit for self-government. And so this was an opinion widely held by Northerners, but Northerners were obviously more interested in seeing that freedom be done. So slaves were relatively better off in some sense, but economically not so much. Maybe they were even worse shape economically. And so how can you be successful in this class? Well, you come to class whenever we have classes, whether it's online. You come to class and attend it if you can. If you can't come, you will be excused. If you're ill, if you think you got the coronavirus, or you got a flu, you're throwing up, or you got a fever and a dry cough, for something like that, you should be relieved from that. If you're going somewhere on a school-sponsored activity, that also gives you an excuse not to be in class. So I usually have in the past said that 3 unexcused absences, I will deduct maybe a letter grade for persons who have 3 unexcused absences. I don't know if I can do that anymore, because I think a lot of people are going to be claiming to be ill, and it might not be fair to just follow that, because it's difficult to determine who is actually ill and who isn't. And and so rather than do that, I will, however, still do something that I've always done. I've always looked at attendance, and I'll look at the students as a group. If the students as a group are attending the lectures, then I'm willing to say that if there's a question on the test, which will be largely based upon the lectures, that 50% or more got wrong, then I'm liable to throw it out as maybe being badly worded, and then I'll rewrite the question so maybe next time it will be more understandable, or I'll try to do better in my lectures so that more people understand the issue involved. Some of my questions can be quite hard. Anyway, so and I know that. So we will do that. I've been told to use characters, so I thought about using Snidely Whiplash and Little Black Nell as characters, with Snidely Whiplash being the plantation owner and Little Nell being a black woman who's being economically taken advantage of under this sharecropping system, and maybe seeing her menfolks being grabbed up and sent off to prison because they didn't sign a sharecropping contract or couldn't show that they were employed. In one case, one notorious case, the person just was visiting his relatives in another county. They arrested him because he couldn't produce his employer, who was from another county, you know, and that person didn't come testify for him. And so it was a very bad system indeed. So your success would be partially based upon coming to class. Since I'm grading on the lectures, you would want to hear what I have to say on the lectures. So the lectures will contain both the PowerPoints that I have, and a lot of that parallels what the lecture's about. So the lectures were based upon the PowerPoints, and also there will be a picture of me, moving picture of me, you know, because this camera can do that, usually in a box where I'm talking. If you can read lips, you might be able to benefit from that. Or if you just find that looking at the face of the person talking helps you to understand what they're saying better, you will be able to see me talking in these videos. So we'll be doing some of that. We'll also maybe be doing some classes, hopefully maybe, where we're doing some sort of a presentation mode that can show things and even be possibly accents, two-way, where you can respond to me live, so to speak, say in Zoom or Webcom or WebEx or some other system that allows us to do that. And I'll embed questions in those presentations on both the lectures that are videos and maybe on the others, the ones that are live, so to speak, where, you know, there's face-to-face, asynchronous. Yeah, I think that's what it's called. So whether it's asynchronous or synchronous, there may be questions. And so, so contract law and regulatory law and the law of the court system, court constitution, and you know, torts, which is the law of wrongs. There will be a test on each of these, which will be very important. They will represent maybe 75% of the grade. And then the other 25% will be perhaps based on the, attendance, if I can get decent numbers on that, and also participation and group presentations and homework that I will assign, which is like looking at a video on TED and talking about it. Okay, and so I think did I tell you that the grades? I get anybody who gets 90% of the questions or 90% of the points available will get an A. And the same way on the test, if you get 90% of the questions right, you get an A. Actually, an A minus for 90%. If you get 91 or higher, you would get an A. So I do give A minuses, B minuses, C minuses, D minuses, but I do not give A pluses, B pluses, C pluses. I do give these minuses just at the break-even point. So you need to strive for excellence. Anyway, Office hours, I have office hours usually 6 hours a week. Oftentimes it's going to be after my classes on Monday, Wednesday, and Friday for 2 hours. If my class is in at 3 o'clock, it'll be till 5 o'clock. And if it's at 4 o'clock, it'll be at 6 o'clock. And so I might, on some occasions, move the ones on Friday to Thursday, depending upon what's going on in my life. But I'll post that and let people know. So we'll keep in contact through the internet. So how is business law relevant to your life? Well, it's very relevant to your life. You're going to be signing contracts. You're going to be employed. If you're employed, it's good to know employment law. How many of you are going to be employed? Well, all of you, right? And those of you who are not, well, you'll be employers, right? It's the way it works. You got to have income coming in from somewhere. So, yeah. So, I guess you could be a passive investor and invest in something like rent. But even there, you need to understand the law that applies to rental contracts. So, business law is very important and very relevant to people's lives, and you'll need to know these things. Even something like the constitutional law, you're hearing it in the news all the time, and you're getting, I mean, unless you have some sort of knowledge about how the Supreme Court has worked throughout the years, it's very difficult to understand what these commentators are talking about and why there is all this objection to that. And so we will talk about those things. And hopefully we will talk very respectfully, and I'm sure I will talk very respectfully to all students and take anybody's views into account. A lot of the views are simply a matter of what they know, and so maybe in this course people will to some degree change their minds. It's part of being educated is that you expand your horizons. Thank you very much for listening to this. I hope I've told you everything you need to know, and if not, it'll all be on the syllabus in any case. Thank you.